Well, that cut off abruptly. Good evening, everybody. Hi, welcome to Case by Case. I'm Amy. I'm joined tonight with Charee. Say hello, Charee. Oh, wait a minute. I have two Charees. How'd that happen? Hi.
Hello.
Which one? There you are. I'm like, which one is she? For some reason, we have, let me see here. I'll kick that one. Kick guest. There we go. Are you there?
Yes.
Okay. Well, good evening, everybody. Welcome to Case by Case. Tonight, we're waiting on Travis to pop in. We are going to continue to review the post-conviction appeal brief that John Pinnow signed in Ashley Garth's post-conviction relief case. Welcome in, everybody. If you were here last week, then we went through the first 20 pages. It wasn't quite 20 pages. We skipped the index and whatnot. And that was just a basic overview of the arguments of the case and what the state and what the defense were both discussing. Let me just kind of breeze through here really fast. If you are new to the channel, we have, for a little over 2 years now, we have been working behind the scenes on Ashley Garth's post-conviction case. There's Travis. Hey, Travis.
Howdy.
So we've been working behind the scenes, helping do research and collect information to help her in her efforts to get relief during her post-conviction relief process. And we had a post-conviction relief evidentiary hearing in November that Charee and I attended in Newton County in Indiana. And it was a one-day hearing, and John Pinnow, who's currently representing Ashley, presented some new evidence. He was able to get some new things on the record, and we all were minimally optimistic because, of course, it was in front of the same judge who overseen the trial, and of course, he denied the petition. So now we are going to the appellate court, and John has filed a very, very well-written brief, and that's what we started going over last week. And it kind of goes through, if you guys were here last week, I'm sure, we went through the statement of the issues, the statement of the case, statement of facts. We got all the way through. And literally we are right now at the best arguments in the post-conviction appeal brief. We're getting into tonight all of the new things that John is arguing on Ashley's behalf. And I think we all felt he did a very good job. We're very optimistic. And as soon as, Travis or Charee, do either one of you want to add to that before we get started?
I'm good.
I know that I don't think I linked it in the description, but I will link last week's live in the description. And we have begun to we've begun to recover the case after over 2 years of working on the case. We even have more now than what we had when we first started covering it on our lives. And, we truly believe that Ashley, if she gets a new trial, we believe that she'll get to come home. This case it's got its rough edges, but there's plenty of evidence here that will overcome the guilty verdict that she was given at her original trial. There wasn't really a defense put on in her case, and we have quite the defense now to put on if she was to get back in front of a jury and a judge. So, Travis, if you're there, do you have anything to add before we get started?
No, I don't. I think you covered it. Depending on, she was awarded a new trial. The whole case hinged on Kurtz's testimony, and his whole situation completely changed. They may not have him as a witness. And without him, I think they'd have to dismiss the case if she got a new trial. But so, yeah, I agree that new trial's going to upend everything.
Yeah. And do you think, what do you think the odds of that happening? Because I was curious going into the November evidentiary hearing. I know that it was John's case to put on, and I know that, of course, Garrett, running his mouth, had told people that he was going to be testifying or be called as a witness there, which he was not. I didn't think that he would be, but this next time around, if she was, by the grace of God, to get a new trial, I think it would really be not in the state's best interest to call him as a witness.
And so, your question was, what do I think that the chances of that happening? What's that she's given a new trial?
Yeah, do you think? If she's given a new trial, do you think? Based on the case as you know it, do you think that the state at that point is just going to throw up their hands, knowing what's been presented in this brief and what Ashley knows now about the case? Do you think, what is the likelihood that the state would more than likely just say, we're going to dismiss the case? Or do you think that they're going to?
Yeah, I think it depends on what Hertz is going to do, and through his counsel, if he even has counsel by that time, it's really going to depend on what he's going to do. True to form, he's going to insist on something, and the something, they no longer have the power to do. A DA can't agree to reduce his sentence, and he's got stacked sentences from two different counties with two different district attorneys. Even if they had the power to go back and ask the judge to reopen those cases, which they wouldn't in Texas, they wouldn't have in any other jurisdiction I'm aware of, but maybe in Indiana, there's, once everything is done, post-conviction and all of that, or the time deadlines expire, the district court, the trial court loses all jurisdiction to do anything, to reduce a sentence, to award a new sentencing hearing. So there's nothing really the DA in either county can offer him. But, maybe he's still driven by spite against things real or imagined, against Ashley or other people out there, that's his motivating force to keep testifying. It gets real, the motivations get smaller and smaller and smaller the longer and longer somebody's institutionalized in prison. Sometimes the motivation to come out and testify at a new trial years and years and years later is simply to get out of the prison and look at the scenery between the prison and wherever the proceeding is, Newton County. It just gets weirder and weirder what people will testify about or what motivates them. Originally, it was, he just so dumb. He should have grabbed an attorney the moment he was apprehended, but he evidently had experience before when he was arrested for these relatively minor things prior to the assaults on Ashley, but he was able to bargain and get out on really cheap bonds. And that's what he thought was going to happen on this case. And he essentially talked himself into a maximum sentence, less 5 years.
Mm-hmm.
And, and that's what his motivation was. And just crazy. But, to your question, if he's not going to testify, is not going to cooperate, or he's going to be as rough on the DA in providing testimony as he was when Lori James tried to cross-examine him, they're not going to have much of a case. Not going to really have any case. So it's really going to depend on that. If he's cooperative and willing to do what he did before, and nothing's changed, then there might be a high likelihood, unless there's just so many factors. It's really hard to predict, but
Mm-hmm.
if it was reversed for a new trial, maybe the trial lawyer that it got assigned to would spend a little time developing the DNA evidence a little bit more, or developing the medical examiner testimony a little bit more,
Mm-hmm.
to show, the prosecutor, look, it's not super clear that it was a ligature. It seems more clear that it was a forearm strangling. When you look at the two factors, it's, there's no DNA on that cord, and the DNA on the scarf is easily explained, how that could have occurred, without actually being involved in anything that was violent towards Nicole, other than the initial fight that she admitted to.
Right. And I think, with the DNA, there's so just a little bit of an amount that is definitely arguable, especially when I'm getting ready to pull up these images right now, since you brought it up about Garrett's arm. There's almost no question. In Ashley's interrogation, she describes what Garrett did, and she describes which arm he used in that interview. And then when they come in Garrett's second interview and they begin to take photographs, it's exactly the same arm that she said that he used. And these images that are on the screen are from Nicole. This happened to Nicole around the midnight hour between the 28th and the 29th. And these photos right here were taken on April 4th. So we're talking over 8 days, and he's still bruised like this, after Ashley described him putting her kind of like in a full Nelson.
Well, and then Kurt's admitting a full Nelson, except he was substituting Chris Mathis. Did I get the name right? You always have to check me on names.
Chris Mathis.
First
Yeah.
interview, he said, "Well, yeah, Chris Mathis unalived Nicole," and he described how Chris Mathis did that, and I think he used the term full, got her in a full Nelson, and yeah.
And then I wanted to really, before we start reading this brief, I wanted to get your take on this, because this was right after John filed the brief. The the deputy attorney general filed an appearance in this case.
Yeah. So who was? That could be anything. Who was appearing before, like at the evidentiary hearing? Who was representing?
It was the prosecutor. She was I can't think of her name. She was the assistant DA to Jeff Dorinsky, the original prosecutor who tried Ashley's case. He's
Rebecca.
no longer. Yeah, Rebecca. What is it?
Goddard.
Goddard, yes, Rebecca Goddard. She's now the sitting prosecutor in Newton County. But I do recall John explaining that he would. Now maybe I'm wrong, but and Charee, maybe you overheard him discussing this. That he said he was going to file this with the Attorney General's office. Does that sound correct?
File what?
The brief, the appeal.
No, you file the brief with the court. You copy different attorneys. Now, normally, what happens in the trial court, like the post-conviction review, so direct appeals are normally all punted to the Attorney General's office, the Criminal Appellate Division of the State Attorney General's office. That's the way it is in Wisconsin, and it's the way it is in Texas. So the post-conviction review evidentiary hearings typically handled by the DA's office in that county. The way it's done in Wisconsin, Texas, and apparently that's the way it was done here. The DA's office handled the evidentiary hearing in this post-conviction review case, and then the moment the judge denied it, and John filed an appeal to the Indiana Court of Appeals, typically the AG's office takes over at that point.
Okay.
So that wouldn't be a surprise whatsoever. But Charee, is that kind of what you heard?
I didn't hear him say, or John say that. I wasn't, right there all the time he was talking, but Amy had told me. So that's
Yeah, he did bring up something. He was talking to me and Ashley both, and I heard him say it, and I had asked her about it, and she didn't understand what he meant. And then when we got the brief, Charee pointed out that the AG had filed an appearance, so that's why I was asking for clarification. But if it's standard procedure that the AG's office will take over, then I'm assuming that's who's going to argue the case on the state's behalf. Then they're going to be the ones to file the brief in response.
That's typically the way it's done. That's how it's done in Wisconsin, and Indiana is very, very similar to Wisconsin. They're right next to each other, and they're both in the same federal circuit. So they, seem to mirror each other in a lot of ways. I haven't looked it up, and nothing's come up yet for me to, Michael would know immediately. And so the next time Michael's on something, or if he pops in the chat, we can ask him. But that's typically the way it happens. The district attorney's office, whether it's the elected DA or someone in the office, handles matters in the trial court like an evidentiary hearing. And then once it goes up on appeal, the AG handles the appeal. So that docket that you showed, was that the docket for the Indiana Court of Appeals, or was that the docket for the Newton County?
That was for the Indiana Court of Appeals, I believe. If you give me one second, I can pull it back up. Yeah, because it's under a new case. I believe it's under a new case number. Oh, yeah. Never mind. I already closed it. I closed it.
Okay. Yeah. It would be, so yeah, everything gets a new number once it gets docketed in the Court of Appeals. And so it's clear to me, it's, this is the way it normally goes, because those are two completely different dockets. They don't transfer over. They don't carry over. So you have to file a new notice of appearance. Now, John maybe didn't file a notice of appearance, because when you file the brief, your brief, that is your notice of appearance.
Okay. And and with it being similar to Wisconsin, what does the AG's office have? 30 days to respond, to get their brief in response?
Typically, but then, they typically get an automatic extension by agreement. If they ask John for an extension, normally he'll approve one. It just kind of depends. I don't know how busy they are, but they generally are going to get an extension, at least one if they need it. So, I'd say their brief's going to be due 30, 60 days. That docket system, the next time you go on there, that particular docket system is similar to the one that they use in Wisconsin. It normally indicates the date that the brief is due.
Okay. Well, before we get off here, I'll pull that back up, and we'll look at it.
But yeah, most states it's 30 days for the opposing party to file their brief in opposition, whatever they call it. And then it's usually between 15 and 30 days for John to file a reply brief.
Okay. Well, let's get started on the document. Charee, I can read, or do you want to read the summary of arguments, or I can start it? And then it goes into, we'll go through the summary of arguments, and then it goes into argument one, and they're both about 2 pages each, so it doesn't matter.
I can start, I guess.
Okay, go ahead.
Okay. Garrett Kurtz testified Ashley Garth helped him in the ligature strangulation of Nicole Bowen, which occurred on March 28th, 29th of 2019. Garth was convicted in 2021 of murder, conspiracy to commit murder, and assisting a criminal. Garth alleged Kurt's ligature strangulation murder of Ray Hainish almost 2 weeks before Bowen's murder was newly discovered evidence. Kurtz was charged with Hainish's murder in 2023 and pled guilty in 2024. The post-conviction court made findings of fact where it found Garth had proved 8 of the 9 requirements for proving newly discovered evidence. Its conclusions of law are not supported by and often conflict with his factual findings. The factual findings are supported by the evidence and are not clearly erroneous. The court's conclusion, Garth did not prove the newly discovered evidence will not produce a different result, is subject to de novo review.
What is de novo? Will you explain that, Travis, what de novo review is?
It's Latin for brand new again. So it would be So a lot of things on appeals, the appellate court has to give deference to. So fact finding, for example, appellate court isn't going to make findings of fact. They'll defer to the trial court, the evidentiary hearing. But how those facts are applied toward the law, there's different ways an appellate court can review it. One way is to just look for clear misapplication of law to the facts. Another is to look at it brand new again. So that's the best possible. If you're a criminal defendant, you want the appellate court to look at it brand new. You want the appellate court to determine on its own what the law of Indiana is given this set of facts. So it's going to be a brand new look at whether the law of Indiana allows for a new trial under these facts.
Okay. Okay, go ahead, Charee.
Whether the evidence is material and relevant, whether the evidence is merely impeaching, and whether the evidence will probably produce a different result are the most disputed parts of the 9-part test for newly discovered evidence. The evidence is material and relevant. Kurt's ability to incapacitate and murder Hainish by ligature strangulation without assistance suggests he had a similar capacity to kill Bowen without assistance from Garth after he had choked her out. Bowen's presence with Kurt's in Hainish's car the day after Kurtz killed Hainish gave Kurtz a motive to kill Bowen as a potential witness against him. The evidence is not merely impeaching. Defense counsel attempted to impeach Kurtz, but was mostly unsuccessful. Kurtz stonewalled questions about previously strangling Garth. Kurtz turned an inconsistent statement in a letter into an insistence Ashley and I both killed Nicole, and Kurtz claimed lack of memory in initially accusing Chris Mathis of killing Bowen. Evidence that Kurtz killed not just one person but 2 by ligature strangulation, that Kurtz had an independent motive to kill Bowen, and that Kurtz falsely accused other men in killing Hainish destroys the credibility of his testimony. Garth actively assisted him in strangling Bowen. The newly discovered evidence will probably produce a different result. Kurtz killed Ray Hainish by ligature strangulation without assistance about 2 weeks before he killed Bowen. Bowen was with him in Hainish's car the day after Kurtz likely killed Hainish. She was a potential witness against him. That gave Kurtz an independent motive to kill Bowen. Kurtz falsely accused other men of involvement in Hainish's death, just as he had made false accusations about Bowen's death. Kurtz's trial testimony was subjected to limited impeachment because he stonewalled questions about previously strangling Garth, aggressively turned cross-examination about inconsistent statements in a letter to Garth, to insisting both he and Ashley killed Nicole, and claimed lack of memory when questioned about accusing someone else of killing Bowen. Evidence that Kurtz had been convicted of another murder and the relevant circumstances of that murder would have destroyed Kurtz's credibility. Kurtz testified Bowen was wearing a white hat, and he believed Garth ended up with her white hat. Garth was wearing a white hat when the police first questioned her. The prosecutor in closing arguments relied on Kurt's claim to argue Garth took Bowen's white hat as a trophy. Trial counsel's performance was deficient when she did not present evidence at trial that Garth had her own white hat and was wearing it when questioned by the police. Garth was prejudiced because the evidence would have undermined Kurtz's credibility on evidence the state was relying on to bolster his credibility. Appellate counsel's performance was deficient when she did not make Kurtz's letter Exhibit E and her offer of proof part of the record on appeal. Counsel could have relied on Appellate Rule 31A to submit a statement of the evidence that would have made the record complete.
Okay, I can go. So argument one, or before we go on, do we want to discuss that section? I personally liked how he brought up, he made it very clear that not only in Hainish's case, Kurtz accused other people, but also in Bowen's case. And that was one thing that really wasn't hammered home on at the evidentiary hearing, was the fact that Garrett had an independent motive to take Nicole's life because she was more than likely a witness to Ray's case. That was kind of something that I felt was overmasked by the prosecutor consistently objecting and arguing. What do you think, Charee?
No, I agree. 100%.
And then the fact that he then again points out the letter, and let me ask you this, Travis, in comparison to the argument, because in this brief, he argues that the trial counsel was deficient because she failed to make the letter that Garrett wrote part of the record on her appeal. And that was because, it was a motion of limine before the trial even started that the whole letter couldn't come in because it included information about Ray's death, which was not allowed at Ashley's trial. And the prosecutor at the evidentiary hearing argued in response to that, basically, that's too bad because the parts of the letter that were admissive in trial were read and were part of the record. And that record was part of the transcript that went to the appellate court.
I thought it made mention in the statement of facts up above that something that on the direct appeal, I thought that they said, we can't tell because the letter's not in here, but we could tell from the record about the testimony that parts of the letter were read. I don't know what the state was trying to argue at the evidentiary hearing, but my recollection is the letter wasn't in the appellate record. And so what he's arguing in this brief is he was saying, Lori James was saying, well, I couldn't make that argument because it wasn't in the record. And what he's pointing out is she was deficient, ineffective, because there are a multitude of ways to supplement the record. And he's giving one example here that she could have done. Now, as to the merits, we'll see here as you read through it, just what the argument is about what was the effect of not seeking this supplementation.
Okay. Okay, well, I will start reading. Argument 1. Newly discovered evidence requires a new trial. Garth alleged newly discovered evidence requires a new trial, PCR. The post-conviction court made findings of fact in paragraph 36 to 43 that were favorable to Garth on her allegations, made contrary conclusions of law on many of the same allegations, and denied relief on the newly discovered evidence allegation. Garth, as the petitioner appealing from a negative judgment, has the burden of showing this court that the evidence leads unerringly and unmistakably to conclusion opposite to that reached by the post-conviction court. The post-conviction court's findings and judgment will be reversed only upon a showing of clear error, that which leaves us with a definite and firm conviction that a mistake has been made. The findings must be supported by the evidence and the conclusion supported by the findings. The appellate court reviews the post-conviction court factual findings under a clearly erroneous standard, but do not defer to the post-conviction court's legal conclusions. State versus Stevenson. A petitioner alleging she is entitled to a new trial based on newly discovered evidence must establish 1. The evidence was not available at trial. 2. It is material and relevant. 3. It is not accumulative. 4. It is not merely impeaching. 5. It is not privileged or incompetent. 6. Due diligence was used to discover it in time for trial. 7. The evidence is worthy of credit. 8. It can be produced upon a retrial of the case. 9. It will probably produce a different result. State versus, I can't read that, McCurry. The court in paragraph 36 found that evidence Kurtz murdered Ray Hainish by ligature strangulation was not available at Garth's 2021 trial, since Kurtz was not charged with that murder until 2023, and defense counsel was unable to present evidence about Hainish's murder at Garth's trial. The unavailability finding is supported by the evidence and is not contradicted by the court's conclusions. Evidence, material, and relevant. The court in paragraph 37 found that evidence Kurtz murdered Hainish and had been convicted and sentenced for that murder is material and relevant. The court found Kurtz admitted killing a man bigger than Bowen by ligature strangulation without assistance about 2 weeks before Bowen's murder. He had the capacity to kill Bowen without Garth's assistance, and evidence Kurtz killed Hainish was relevant and material to Kurtz's motive to kill Bowen because she was with him in Hainish's vehicle the day after Hainish was killed. The court, in its conclusion of law, contradicted its findings. The evidence was material and relevant. It concluded Kurtz's murder of Hainish was not material and relevant because Hainish willingly submitted to being restrained and choked while Bowen was fighting with Garth when Kurtz put Bowen in a chokehold and Garth helped him strangle Bowen. The court concluded no evidence was presented Bowen was aware of Hainish's death or Kurtz's involvement in it. Garth disagrees with the court's conclusion on the materiality and relevance of Kurtz's murder of Hainish. Kurtz testified Garth helped him in the ligature strangulation of Bowen. Kurtz, by his guilty plea to Hainish's murder, admitted to the ligature strangulation of a man bigger than Bowen about 2 weeks before Bowen's murder and without the assistance of anyone else. The court reasoned the ligature strangulation murders were distinguishable because Hainish willingly submitted to being restrained. However, the common theme is both victims were incapacitated before Kurtz killed them. Kurtz first incapacitated Hanish by tying him up as part of a sexual act. Kurtz incapacitated Bowen by first choking her out. Her body was found with tape around her ankles. Her arms were taped together at the wrist behind her back, and a scarf and electrical cord were tied around her neck. Evidence that Kurtz killed Hanish was material and relevant to Kurtz's motive to kill Bowen because she was a potential witness against him. Evidence of Kurtz's motive to kill Bowen would have been admissible under Evidence Rule 404B, Fry versus State. Defense counsel would have wanted to present evidence on Kurtz's motive to kill Bowen. Do we want to discuss before we go on?
I didn't really have anything noteworthy. I don't know if Charee does.
No. Did you?
I have a question on your opinion, Travis, on how strong the argument is that he's raising about the fact that, I know when we get further in here, he does discuss the fact that the reason they did go seeking Nicole because they did feel that she had information about Ray's death, but Garrett got to her before they did. But how strong of an argument do you feel this is that he's raising about the fact that he was able to kill Ray Hanish, someone who's bigger than him, alone, and comparing that to him being able to kill Bowen? Is that a strong argument, do you think, or is it just one that has to be raised?
No, I think it's a very strong argument because, this needing help and everything that was argued up to that point at trial or in the evidentiary hearing, from what I understand, was argued at the evidentiary hearing. That's a big deal. And so this serial strangler, as John described it, and that these, what I've termed psychopathic behavior, that was mentioned in this brief somewhere, that I guess during the plea of the murder of Ray Hanish, that his attorney described Kurtz as a Jekyll and Hyde personality, that that is the most consistent explanation for what happened. Is he snapped like he snapped with Ray, snapped with what he was doing with Ashley, and then just snapped in a split second with Nicole. So no, I think it's very strong. It supports an overall picture of somebody who is Jekyll and Hyde, who can, turn on you in an instant, which, by the way, all of the science and studies behind chronic meth use, they have the number, how much more likely somebody in a relationship with where both people are meth users, or one is a chronic meth user, how much more likely it is to be seriously hurt or killed by somebody in that situation. But it's all consistent with a chronic meth user in terms of their paranoia, their violence. So no, I think it's extremely important, and he argued it extremely well, in my opinion.
Good. Okay. I can keep going. So he argued it before he argued it before Bowen's murder, did it by himself, and Bowen's knowledge of his involvement with Hanish gave him a motive to kill Bowen. The court, in its conclusion of law, partially contradicted its finding in Did we already read this? I don't think so. Okay. The court, in its conclusion of law, partially contradicted its findings in paragraph 39 by emphasizing Kurtz was thoroughly impeached during the trial and the jury was aware he was a murderer. Kurtz admitted he was convicted of murdering Bowen and he received a 55-year sentence. The impeachment value of that conviction was limited because Kurtz asserted he was not getting anything for testifying, and he was testifying because the mother of two boys was taken away from them and he wanted to make it right. Defense counsel relied on other evidence to impeach Kurtz. First, the submitted evidence Kurtz had earlier been accused of strangulation and invasion of privacy where Garth was the alleged victim. She asked Kurtz about those charges. He responded they had been dismissed and he refused to talk about them. He stonewalled the question and counsel was unable to further persuade the issue. Second, counsel attempted to impeach Kurtz with his letter to Garth, where he stated, "I killed Nicole because I was protecting you." Kurtz responded, "We both killed Nicole. Ashley and I both killed Nicole." Kurtz turned the attempt at impeachment into an opportunity to further incriminate Garth. Third, defense counsel asked Kurtz if he recalled blaming the murder on anyone else. He responded, "No, I did not recall telling Detective Rowe that Christopher Mathis killed Nicole because he was higher than a kite." Counsel was unable on cross-examination to impeach Kurtz with his video statement, but had to rely on later testimony from Detective Rowe. Kurtz was impeached, but the impeachment was not thorough because Kurtz stonewalled the questions, took the offense, and claimed lack of memory. The post-conviction evidence went from further in destroying Kurtz's credibility. First, Kurtz killed not just one person, but two. The credibility of a felon witness like Kurtz is highly suspect. Kurtz's explanation he was testifying because he wanted to make it right rings hollow if the jury had known he had killed Ray Hanish about 2 weeks before he killed Bowen. That was a great statement right there. Second, Kurtz killed two different persons by ligature strangulation. A jury is likely to more critically evaluate testimony when it comes from someone who serially strangles his victims. Third, Kurtz has a predilection for accusing others when accused of serious crimes. He falsely blames first one man and then another when he was questioned about Hanish's death. He falsely accused Chris Mathis. It is not much of a stretch to find he falsely accused Ashley Garth. Fourth, is Garrett Kurtz the kind of person from whom you would buy a used car? No, he takes the cars from the people he killed. First Ray Hanish, second Nicole Bowen. He claimed he had Hanish's permission to drive his car when Hanish was already dead. He tried to transfer the title to Bowen's car the day after killing her. Evidence which destroys or obliterates the testimony upon which a conviction is obtained is not merely impeaching. Wilson versus State. Charee, you want to do this next couple ones?
Okay. Evidence is not privileged or incompetent. The court in paragraph 40 found the evidence is not privileged or incompetent because Kurtz gave up his right against self-incrimination by pleading guilty to Hainish's murder. This finding is supported by the evidence and is not contradicted by the court's conclusions. Due diligence was used to discover the evidence. The court in paragraph 41 found due diligence was used to discover the evidence because Kurtz was not charged with Hainish's murder until after the trial, and defense was not able to present evidence about that murder at Garth's trial. This finding is supported by the evidence was not available at trial and is not contradicted by the court's conclusions. Keep going. The court in paragraph 42 found the evidence is worthy of credit. It noted testimony from detectives A.J. Smith and Eric Janke, detailed the evidence that led to Kurtz being charged with Hainish's murder and auto theft, and Kurtz pled guilty to Hainish's murder rather than contesting the case at trial. This finding is supported by the evidence. The court, in its conclusions, states Garth's contentions about the connections between evidence about Hainish's death and Bowen's murder are speculative, not supported by the evidence, and not worthy of credit. The court did not find the testimony of Detectives Smith and Janke to not be worthy of credit based on their demeanor, but because their testimony was not supported by the evidence. The court can independently assess their credibility and determine whether their credibility is sufficiently consistent with the record to be worthy of credit. Whether a witness's testimony is worthy of credit often arises when there are reasons to doubt the credibility of witnesses testifying in support of newly discovered evidence. Testimony of one witness lacked credibility because she told the police on the day of the incident that she saw nothing. Testimony of witnesses lacked credibility since they were not disinterested and connected to the defendant. Recantation affidavit from child molesting victim was not worthy of credit given circumstances under which the affidavit was obtained. The court did not challenge the credibility of detectives' testimony, but its focus is on whether the evidence is material, whether it would probably produce a different result. Those conclusions are discussed in the appropriate subsections.
I can go.
Okay.
Evidence can be produced on retrial. The court in paragraph 43 found the evidence can be produced on a retrial of the case. This finding is supported by the evidence and is not contradicted by the court's conclusions. Evidence will probably produce a different result. The court did not make a finding on this portion of the 9-part test for newly discovered evidence. The court, in its conclusion of law, ruled the evidence is unlikely to produce a different result. The court's conclusion is reviewed de novo. The court's conclusion is erroneous. Garth's case is similar to McCurney Supra, where newly discovered evidence resulted in a new trial. In McCurry, the victim was fatally shot after confronting 5 young men over a missing shotgun. Austin Mitchell accused another man of the shooting. In his 4th statement, he admitted he shot the victim, but also accused McCurry of shooting him. Mitchell pled guilty to murder and testified at McCurney's trial. He shot the victim, and McCurney then shot him 2 more times. McCurney was convicted of voluntary manslaughter. Years later, Mitchell testified at McCurney's post-conviction hearing and recanted his trial testimony. McCurry shot the victim. The post-conviction court ultimately found that the recantation credible and ordered a new trial based on newly discovered evidence. The Supreme Court affirmed that ruling. Kurtz, like Mitchell, initially accused someone else. He accused Chris Mathis of killing Bowen. Garth accused Kurtz of killing Bowen. Kurtz then confessed to killing Bowen, and then implicated Garth, just as Mitchell confessed to killing the victim and implicated McCraney. Kurtz pled guilty to Bowen's murder and testified at Garth's trial that both he and Garth killed Bowen. Garth was convicted. Kurtz, unlike Mitchell, did not recant his testimony at Garth's post-conviction hearing. Instead, Garth presented other evidence with the jury, which the jury did not hear, that destroyed his credibility. Kurtz killed Ray Hanisch by ligature strangulation about 2 weeks before Bowen's death. He took Hanisch's car, like he took Bowen's car after her death, and was stopped by the Lafayette police a day after the murder. Bowen, who was then Kurtz's girlfriend, was with him and another man. The detectives who investigated Hanisch's homicide could not question Bowen because she was already dead. When the detectives confronted Kurtz about Hanisch's death, he falsely accused 2 other men. Kurtz pled guilty to Hanisch's murder 3 years after Garth's trial. He admitted he, and only he, killed Hanisch. Hanisch was bigger than Bowen. Garth proved the newly discovered evidence would probably produce a different result. Argument 2. Garth was denied the effective assistance of counsel at trial and on appeal. Garth alleged she was denied the effective assistance of counsel at trial for not permitting evidence she had her own white hat and was wearing it, and not Bowen's hat, when questioned by the police. She alleged she was denied the effective assistance of counsel on appeal for not making Kurtz's letter and her offer of proof at trial part of the record on appeal. The post-conviction court concluded counsel's performance did not fall below an objective standard of reasonableness and that she was not prejudiced to the point the result of the proceeding would have been different. The standard of reviewing ineffective assistance of counsel claims was set forth in Strickland v. Washington. First, the petitioner for post-conviction relief must demonstrate counsel's performance was deficient. That is, that it fell below prevailing professional norms. Second, the petitioner must show a reasonable probability of a different result to prove prejudice. Garth has the burden on appeal of showing factual findings made by the post-conviction court were clearly erroneous, while its legal conclusions are reviewed de novo. Not presenting evidence, Garth owned a white hat. The court ruled out of an entire 5-day jury trial, the only thing James is alleged to have done wrong is to have not presented unreliable evidence of Garth owning a white hat. There is no indication that James even knew or could have known the significance of the white hat because Garth had never disclosed to her that she had stolen the hat. Even if it is true that Garth owned a white hat, the fact doesn't mean that Garth didn't take Nicole Bowen's white hat. Kurtz testified at trial that Nicole Bowen was wearing the white hat when he picked her up on the day of her death, and that he believed Garth took that hat after Bowen died. Oh, what a tangle web we weave when we practice to deceive. Grund versus State, quoting Sir Walter Scott from Miriam, A Tide of Flooden Field. The state relied on testimony from Garrett Kurtz. Even before the post-conviction evidence is considered, he had dubious credibility. He took the murdered victim Bowen's car and tried to transfer its title, accused Chris Mathis of killing her when confronted by the police, and eventually pled guilty to Bowen's murder. Kurtz is an unreliable witness. The state chose to call him at trial and relied on his white hat claim in closing arguments. The consequence of calling an unreliable witness practiced in the art of deception is that the parts of the case which rely on its credibility become tangled and fall apart when given scrutiny. The unsupported theory Garth should have disclosed to trial counsel that she took Bowen's hat is contradicted by the evidence. Trial counsel testified testified Garth told her at trial she did not take Bowen's hat and she had her own white hat. She did not admit to stealing Bowen's white hat. Trial counsel's performance was deficient when she did not present evidence at trial that Garth was wearing her own white hat and was not wearing a white hat taken by the victim. Ellison versus State. In Ellison, the defendant was charged with burglary and rape. The defendant's ex-wife testified about the alleged rape. Trial counsel was held to be ineffective for not submitting a rape kit favorable to the defense as evidence and impeaching her with prior inconsistent statements. The Court of Appeals stated, because the only direct evidence of husband's guilt was contained in the wife's testimony, wife's impeachment became an important matter at trial. Had her credibility been called into question, the result reasonably could have been altered. Husband was not required to prove himself innocent below. His task was to raise a reasonable doubt as to her guilt. Within the confines of this case, wife's inconsistent statements might well have placed the requisite doubt in the fact finder's mind, the result being a judgment of not guilty. Presenting evidence at trial that Garth had her own white hat and was wearing it when she was interviewed by the police would have created reasonable doubt about Kurt's veracity. Garth did not have to prove she could not have taken Bowen's white hat. The court alternatively concluded because the photograph of Garth wearing a white hat predated the murder, was taken on Snapchat, a messaging platform known for its ability to alter photographs, it may not have been considered admissible evidence at trial, and James' decision not to admit it was a strategic one entitled to difference. Trial counsel expressed no such strategy in her testimony. Instead, she presented evidence at sentencing through Garth's grandmother about Garth wearing a white hat. The photograph of Garth wearing a white hat at her niece's birthday party was admitted over the state's objection at the post-conviction hearing. An objection based on the photograph being on Snapchat, which was not an objection the state made, would have gone to the weight of the evidence and not its admissibility. Provolich versus State. The court concluded, even if Garth did own a white hat and James could have produced this evidence, Garth hasn't shown that James' performance was so deficient that the defense was prejudiced at all, and certainly not to the point that the result of the proceeding would have been different in light of the evidence against Garth at trial, including a witness testimony, her own partial admissions, and DNA evidence. The court's conclusion is reviewed de novo. Stevenson, Supra. The conclusion is erroneous. First, the primary witness testimony came from Kurtz, a felon witness of dubious credibility. Evidence Garth had her own white hat and was wearing it undermines Kurt's credibility on evidence the state relied on to corroborate his credibility. Second, Garth in her pre-trial statements admitted Nicole was like an enemy, her boyfriend's other girl, and they got in a fight. Garth denied grabbing her, denied having her arm around her head, and denied having her in a chokehold. She denied grabbing an extension cord, did not hand anything to Kurtz, and denied helping tape up the body. Garth put herself at the scene but denied active involvement in helping Kurtz strangle the victim. Third, the DNA evidence is not incriminating as it first appears. There was very strong support Garth's DNA was on a fingernail scraping taken from Bowen. That evidence is explained because Garth and Bowen were fighting before Kurtz choked Bowen out. There was no DNA evidence on the extension cord used in the ligature strangulation. There was strong support Kurt's DNA was on Bowen's scarf, while there was limited support Garth's DNA was on the scarf. Kurt's DNA and not Garth's DNA was on a partial roll of duct tape. There was a strong support that Garth's DNA was on a cardboard tube found with the body. The DNA evidence puts Garth at the scene, but does not prove she actively aided Kurtz in strangling Bowen. Fourth, the prosecutor relied on Kurtz's testimony about the white hat in closing arguments. Fourth, the prosecutor relied on Kurtz's testimony about the white hat in closing arguments. The state's reliance in closing argument on Detective Conway's denial he fed information to defendant entitled defendant to post-conviction relief. The prosecutor began his closing argument with, "Killers keep trophies. Is it the spoils of war? Is it the thrill of the hunt? Or is it just a sign of victory?" Hold on 1 second. Let me read that over. Sorry. I think I skipped. Okay. Fourth, the prosecutor relied on Kurtz's testimony about the white hat in closing arguments. To the jury, the state's reliance in closing argument on Detective Conway's denial, he fed information to defendant entitled defendant to post-conviction relief. The prosecutor began his closing argument. "Killers keep trophies. Is it the spoils of war? Is it the thrill of the hunt? Or was it just a sign of victory? Do we know? Was the defendant's trophy Garrett Kurtz? Or was it the hat?" The prosecutor argued in rebuttal closing argument. "She even wore Nicole's hat to the police station." The prosecutor's argument echoes a quote from the 1958 movie Vinigo. "You shouldn't keep souvenirs of a killing. You shouldn't have been that sentimental." Not making Kurtz's letter and offer of proof part of the record. The post-conviction court ruled James did not prepare or submit the exhibits for the appeal. Further, during the trial, James read the admissible portion of Exhibit E to Kurtz during the questioning. So the contents were available verbatim in the record. Since the appellate court was provided with the contents of the letter, even if Exhibit E wasn't submitted with the rest of the trial record, Garth has not shown that she was prejudiced. Because Garth was not prejudiced, this court need not evaluate appellate counsel's performance. Garth's claim of ineffective assistance of appellate counsel is within the category of failure to prevent issues well. Where the appellate court addresses the appellant issue on the merits, relief is only appropriate when the appellate court is confident it would have ruled differently. Counsel's performance was deficient where she failed to present a complete record on the claim she raised regarding the court's exclusion of Kurtz's letter on appeal. Neither Exhibit E nor counsel's oral offer of proof were part of the record on appeal. The post-conviction court concluded it did not matter since counsel read the admissible portion of the letter to Kurtz when it questioned him. This is erroneous because the issue on appeal was the exclusion of Exhibit E, not what the court permitted counsel to question Kurtz about. Counsel's view was the bailiff or court reporter prepared the appellate record with exhibits and she did not know about a way to fix the omission of the offer of proof from the record. However, Appellate Rule 31A provided that if no transcript of all or part of the evidence was available, then a party's attorney may prepare a verified statement of the evidence and request the trial court certify the statements of the evidence. As an example of the use of Appellate Rule 31A. Charee, do you want to read?
Okay. Appellant acknowledges this court on direct appeal ruled the trial court did not abuse its discretion in excluding Kurtz's letter. The court stated it is not the letter itself, but the subject matter of the letter that is the relevant focus for the purposes of Evidence Rule 803-5. Even if you redact out Kurtz's comments about another death, there are multiple probative statements in the letter that did not effectively come out at trial. First, Kurtz was angry with Garth about giving a statement implicating him in the murder. Ashley, I'm going to keep it real with you. I don't trust you. You promised me you'd never say anything to get me in trouble, and here I am in jail facing 50 years because you told on me about what happened. You want to put your mind at ease? Well, put my mind at ease for you snitching on me. Whether the anger motivated Kurtz to falsely accuse Garth is evidence the jury should have heard about. Where a new trial was ordered because of an affidavit from a deputy. All right, I skipped some. Whether that anger motivated Kurtz to falsely accuse Garth is evidence the jury should have heard about. In Key State, where a new trial was ordered because of an affidavit from a deputy sheriff / jailer that a state's witness told him the defendant was not guilty, but he intended to take him with him to the penitentiary because the defendant had dated the witness's wife. Second, Kurtz is concerned about Garth's telling on him are intercut with admissions and implied threats. Well, newsflash, sweetheart, your DNA will get found on Nicole's body too. But unlike you, I wouldn't ever say anything to get you in trouble. Because I actually love you the way I say I do. I killed Nicole because I was protecting you. I didn't want to see her hurt you when you two got in that fight in the living room. The context by the time of trial is that Kurtz had gone to prison for Bowen's murder and he was motivated to take Garth with him. Conclusion: based on the foregoing arguments and authorities in arguments 1 and 2, Garth requests that this honorable court reverse the denial of post-conviction relief, order the convictions and sentences for count 1 murder and count 2 conspiracy to commit murder to be set aside, and order those counts be remanded for a new trial.
Ad lib, Charee.
What do you think? I think he has a very large amount of great arguments. What do you think, Travis? What do you think is the strongest arguments in that brief?
The new evidence part, the way he brought the fact that there was a plea agreement and in the Ray Hainish murder is new evidence that could have been used to effectively impeach and thus reasonably would have led to a different result is brilliant. But as Michael mentioned, he's got a lot more experience. One, he's got a lot more local knowledge because he practices in Indiana and post-conviction. But, these are very, very tough cases. Tiny percentage end up with any type of result that a defendant, can use as a practical matter. And it's very, very difficult. But this argument that because Lori James in the statement of facts, my notes are correct, and my memory from last week mentions in the evidentiary hearing, Lori James was aware of the Ray Hainish incident, was aware that they were investigating him for that. But, I don't know what actually pursued in discovery. Don't know if she got the statement. You know, when they interview, when the people, the detectives in White County interviewed Kurtz. I think we know that from the statement of facts. We don't know whether she got that information, but kind of just I was able to pull all of that out of it and just say, look, putting all of that aside, the fact that the state, and he implies but doesn't say it, that the two counties, the two prosecutors in each county clearly decided which one was going to go first and how this thing was going to go. And then that, in effect, allowed Kurtz to avoid any prosecution for that case until the trial and appeal of Nicole Bowen's murder was complete. That deprived Ashley of very important evidence that could have been used to impeach. Then rather, than saying, oh, it's Brady, and then, having to show all those factors and materiality, just says, hey, this is new and it meets all of the factors. Now, what was interesting to me, and I hadn't ever seen in a post-conviction brief before, is so there's these 8 or 9 factors from this court case, and the trial court judge basically found all 8 factors, but then the 9th and deciding factor, the real important one, doesn't make the finding, which deprives her of a new trial. But he does a great job of pointing out how these things are inconsistent. And the beauty about it, he doesn't have to argue what the facts were at the evidentiary hearing. The judge made the findings in those other 8 factors. So John just gets to say, yeah, the court found that it was this or it was that. And then, inconsistent with those findings, and the 9th and final one says, it wouldn't make a difference. Now, I have some concerns about like the new evidence. He argues several times that Lori James was unable to cross-examine effectively with the prior statements, but he doesn't say, he never says why he couldn't have used the videos to impeach him. Just says, it wouldn't have been able to do that. The other thing, my recollection is that the transcript you obtain from the transcripts you obtain from the trial, including Garrett Kurtz's testimony during the cross-examination, so-called, she trying to cross-examine Kurtz, and then Kurtz would fire back with stuff like, well, her DNA is on I thought he said the extension cord, electrical cord, but I can't remember exactly. But he fires back with, well, her DNA is on something.
That I don't recall if he said that at trial. I know during his cross-examination, he kept telling Ashley's attorney, I'm not discussing that. I'm not discussing that. And
Well, he said that about the prior arrests and the assaults and whatnot, but on the he did say, and it got into evidence. She didn't move. Lori James didn't move to strike it as non-responsive, and didn't request an instruction for the jury to disregard it. He said her DNA is all over something. Look, it's in the DNA report. And I know it was that much. I can't tell you what he said it was.
he might have. Yeah, he might have. I mean, he would. Yeah.
Um, so, and, in the evidentiary hearing doesn't go into, that with Lori James, or, doesn't argue it. So, I'm a little bit concerned about that. But, I think very impressive to go with this new evidence, because you get rid, you don't have to prove prosecutorial misconduct, that there was this intentional plan in terms of the timing of things. So I thought that was by far the best argument. I think it's just really brilliant.
Do you think the argument about the weight of Lori James not including the letter, the letter in its entirety? I think there was only 3 sentences of the letter read out loud at trial. So those 3 sentences were all that made it into the record that went up to the appellate court. And the fact that the whole entire letter didn't make it up there, and the fact that, so that's basically an error. What is that like? Is that considered an error of the record? Would that be considered an error by the trial court? Because I think Lori James was trying to point the finger at the clerk, saying that, well, the letter was turned over to the clerk. It was the clerk's responsibility when she prepared everything to go up to the appellate court. That was the take that I kind of got. But now that they have this letter in its entirety, I mean, that letter really truly does lay out Garrett admitting what he did and why he did it, which that part of it wasn't read at trial.
But
do you think that is going to carry any weight?
Really what he's arguing. He's arguing that she was deficient in not getting a complete record, and that she could have gotten, she went to the court reporter, and the court reporter said, I don't know why it's in there. Well, how can I correct this? I don't know how to correct it. And then John points out, it's simple. You just do an affidavit and then get the court to certify it that an offer of proof was done. So, I just don't think it's very strong. But,
Okay.
Michael's the one to ask on that, because the issue wasn't whether I think what he argues is very, very good. There we can go back to that. What he does say, the issue wasn't whether the issue on appeal wasn't the fact that, well, she got to read the parts that were admissible into evidence. The issue was about what wasn't allowed into evidence. And but he doesn't really say why that's material, how it would have changed the result. At least I didn't pick up on that.
Well, I mean, it's possible because in that, the reason that the entirety of the letter wasn't allowed is because it discusses Ray Hainish being killed. And in that letter,
Yeah, but I didn't see any argument in this brief.
yeah,
Why?
I think he might be, I mean, I'm assuming that he's tying that into the new evidence that in the letter Garrett is admitting, not only did he admit to killing Hainish, but he admits to doing it intentionally and claims he's never had sex with a man, because the prosecutor was implicating the fact that, it's kind of like they're trying to use it as a sword and a shield. They're saying, well, Ray died because he was being submissive in a sex act gone wrong. Well, if that was the case, why did Garrett plead guilty to murder and not not manslaughter or something like that? He pled guilty to murder, and in the letter he basically claims that it was so. But you're right, he does not in this brief outline how that ties into the newly discovered evidence in regards to Ray's case now being presented.
Well, you don't need to necessarily tie it into the new evidence, because each argument can stand on its own and needs to stand on its own. But unless I missed it, I'm not really seeing how he's arguing that if there had been a complete record, it would have made a difference in the appeal on that issue. I mean, there are all kinds of stuff that are errors. Yeah, it's error. You didn't submit a complete record, but they always require you, unless it's constitutional or structural error. None of this is constitutional or structural. But unless it's that, you've got to show materiality. You got to show that it's not merely harmless error. And on the new evidence, to show materiality, it goes through all of those factors, and then the most important being that would have led to a different result, and being it would have led to a not guilty. So he lays that out really, really well. But this thing on the letter and an incomplete record, it does show she was deficient, clearly, but I'm not sure it's, to me, just doesn't seem like it's meeting the materiality standard. But unless I'm missing something, I don't know if Charee heard something different on it, but I'm like, okay, yeah, it's clearly it was error. She could have gotten that into the record, could have gotten the appellate court to review that. So what? Okay, so what would they have done if she had submitted it? That's really on these post-conviction things, what you've got to do. But I may be missing something that he's argued in the brief that I'm just not picking up on.
I'd have to read it again, but I think, and maybe it wasn't brought out clearly, but just the fact that the portion that was left out where the court says, well, it was all in the record because she read it, the admissible parts, but the problem was the part that the court wouldn't let in was about Ray's death, and just if anything about Ray being killed 2 weeks before would have been material, in my opinion, but I'm not sure whether it's brought out clearly in this letter. Maybe that's what he's going for, but
Yeah, now that you say it that way, probably so. I mean, what were your thoughts, Charee, on the new evidence? I've got a bunch of notes that, since it's framed as new evidence, it doesn't get bogged down in, showing intent on the part of the prosecutors and kind of gets away from all the deficiencies in the cross-examination, which I'm assuming it just must be extremely difficult to get a new trial for ineffective assistance of counsel on a cross-examination, which it typically is all around the country, but just kind of looked at it and went, there's no way I'm going to be able to get anything from that. But the fact that, there was this major thing that happened way after the trial and way after the appeal and all of these things, it was going to hamstring somebody one way or the other in the order that Garrett was going to, testify, which trial, and what was going to be the incentive. I've got a note, I don't understand why more wasn't brought up. Because my recollection was the state brought out with Kurtz, now, why are you testifying? Has anything been promised to you? And they're like, no, nothing is promised. And I remember making notes at that time that how could that possibly be? And why wasn't that gone into that? Okay, well, you got 5 years off the maximum of 60. Why wasn't his attorney asked, when did that deal come up? When did this come up? And it's possible that, hey, yeah, there was no done deals. They were very clear about that they couldn't do a done deal. And it was done with a nod and a wink, but there wasn't anything promised, the technical sense of that term, that we'd agree to let him plead to intentional homicide, murder, with only a 55 years instead of the maximum. We left it all open. I mean, there's that possibility, but just that just doesn't seem to be really possible. But we'll never know because it wasn't an issue. I mean, that was surprising to me.
Well, in reality, before Ashley's, let me see here. Sorry. Before Ashley's trial, Jeff Durinsky gave an interview to the media, and I have it here somewhere, where he claimed he was pursuing life without parole for Garrett. This was when Garrett was going to take his case for Nicole Bullen to trial. And he was going to pursue, I've got it in here, life without parole. And so it went from life without parole to the maximum that Garrett should have been 60 years, but he only ended up with 55.
Yeah, something happened. Something happened. Something was said going into that trial. I don't know when the interview was. I remember those talks after the DNA came back. But
well, there it is. I got it. Oh, no, it's not going to say invalid file type, of course.
Does it say when it was?
Yeah, hold on. Let me pull it in. I'm trying to pull it in. The one that I just tried to pull in, it's saying invalid file. Okay, I've got to pull it in as a picture. That's why. Wait a minute. I don't have the date on here. I'd have to. I can pull it up on the.
Yeah. So I mean,
I'll pull it up.
When was Kurtz's plea of guilty and sentencing in the Nicole Bowen case?
It was prior to Ashley's trial, so this was here.
It says Nicole's body was found last week or last
so
Saturday.
it was April 6th that this article was published. Hang on here. I'll pull it in.
Yeah. So did you hear what Charee said? That interview with him with the DA was a week after Nicole's body was found. So that was really early.
Yeah, April 6th. So it would have been after Garrett's first two interviews.
And didn't Garrett plead guilty like in September 20, something like that? And right before that was when the charges against Ashley were dropped in Carroll County.
Okay, so
this says that Kurt's sentenced to 55 years, so this would have been January 13th of 2021. Ashley's trial was in May of 2021. 4 months before. So at this time, okay, but see,
at trial, did she bring up that originally they were talking about seeking life without parole on you?
Nope.
That you were facing a maximum of 60 okay.
No, that was never.
He pled and then and was sentenced before her trial.
They had to have been utilizing him throughout that time simply because, the whole ordeal of the white hat came about. Ashley had on her white hat when she went in for her interrogation video, and that's what he was referencing, was the white hat when she went in to talk to police. And that my issue always was, when Ashley went in that first time and she never left, she was arrested and she was in there for 6 months, and that hat sat there in that property room. So if this was an accusation that Garrett had made from Jump Street early on, why didn't they go get the hat and test it to prove that it was Nicole's hat? It would have had her DNA in it. But instead, this was kind of like a surprise at trial,
Mm-hmm.
Those were.
I think that's why John got it on, that he could, argue it that way, either in the trial court or on appeal, that she should have been ready for it. And then, because then, the panel, the appellate panel, she's surprised with it. What attorney could deal with that? No, you can't. That couldn't be anticipated, that they both had a white hat. And then it's
and that,
if that's the case, Judge, then that implicates the state for not making Lori James aware of it, and was a surprise. And that's where, personally, I've always wanted the argument to be made on Ashley's behalf that they can argue this back and forth about the white hat and James didn't know. Well, they presented the picture that they were going to introduce of Nicole at trial. Yes, Lori James didn't know what the line of questioning was going to be about that picture. However, that picture on its own was a false fact that the prosecution presented as a picture that was taken the day that she died. That picture was not from that day. She did not have on the same clothes. She had on a different nose ring. She was about 20 pounds skinnier. Her face wasn't scarred up. Her mugshot, again, from the arrest and raise vehicle, her face is completely scarred up, which is something that John does bring up in this brief, bringing up Nicole's skin, because it's even discussed in the autopsy that she's got scarring on her face from the heroin use. So the picture that the prosecution presented at trial, I don't know where they got that picture, but Nicole's phone was never recovered. So someone had to give that picture to the prosecution, and odds are they knew on face value that picture was not taken the day that she died. That should have been, I really felt that would have been a slam dunk argument on the fact that not only did the whole white hat story was fabricated, but the whole concept of, she was wearing that hat the day I picked her up because she took that picture the day I picked her up. Yeah. And so, like I said, I think
it's too late now.
New evidence, you just avoid all of that, having to prove prosecutor intent.
Well, that's kind of like
sidestep all of that and not have to show the.
Well, it goes to Garrett. He could have done that going, because all you have to do is say that Garrett lied to the prosecutor. That photo wasn't taken that day. Garrett testified that she took that selfie that day and that Ashley took the hat. Well, if that photograph wasn't taken that day, and earlier you've got Talitha Beckley in her interrogation video stating that Nicole wasn't wearing a hat. She testified at Ashley's trial that Nicole wasn't wearing a hat. I just wish all of that could have been included. But I still think it's a great brief. I really do. I think that John did a very good job. I'm just passionate about it.
What's the cardboard tube
So the cardboard, so Garrett used 2 or 3 different types of tape. And you can see those in the autopsy. You can see it when they find her body. The outside of the blanket is taped up. There's brown tape, there's clear tape, and I think there's duct tape. What the duct tape is a black tape. And whatever rolls of tape he used, some of them, like he wrapped her hands up with the tape, and then instead of like tearing the tape off, he just left it attached to the cardboard tube, like there was still tape on the roll. Well, one of those rolls earlier that day, Ashley had admitted to handling. She had picked it up, tore off a roll of tape to tape the battery into the back of the phone. That phone was the phone that she turned over.
Cardboard tube
had her DNA from where she had handled the roll of tape earlier.
Roll. Okay. I'm picturing like Christmas wrap.
No, it's the card. It's from the tape. But I mean, when you think about where, if she had participated, where all of her DNA should have been, it wasn't. There was no. Her fingerprints weren't on the bag. Her fingerprints weren't anywhere on the tape. They weren't on Nicole's the blanket that she was wrapped in.
But you can't use absence
right
DNA, or you got to have an expert to come in and tell you why it's significant. Unfortunately, but
right.
You know.
So you feeling that the argument of the new evidence and Ray's case, which was allowed to come in at the evidentiary hearing, that being the strongest argument, and everything that goes along with that, the other 2 arguments, about the hat and the ineffective assistance of counsel, and the fact that she didn't get the letter on the record with the appellate court, do those come irrelevant, or do they kind of bolster the stronger argument that they have? Like, are those supporting arguments now, but because they don't really quite meet the standard, are they just going to ignore them?
Well, I think clearly there's a reason why John went to the effort to make those, and I think he's playing chess, and he's 2 or 3 steps ahead of what I can even figure out. I'm part of. I mean, they just don't seem strong to me, but who knows?
Now, with the AG's office, with this going to the appellate, do they typically just rule, or do they also make possible a hearing, like an evidentiary hearing, like we got with the trial court?
All the AG's office is doing is their attorneys are going to prepare the written response. There's the AG's office is a prosecutor. They're
right.
Not allowed. They don't get to request an evidentiary hearing or
no. What I'm saying is that, will the appellate court, do they offer that, or will they if they're going to do anything other than decline the motion, will they hold a hearing?
So, hang on. So the motion and the hearing are done and over. That's done.
Okay.
The only significance about the AG is it's a different law office. And so for appeal, the state has a new law office that's representing the state. So John's filed his appellate brief, and then the AG's office, the new law office for the state, is going to file a response to that brief. That's it. That's the only significant. Different lawyer, it's going to be a lawyer. All they do is respond to post-conviction appeals. That's it. Or if they lose on one, they appeal it. But all they deal with is post-conviction issues. Just like John, all he deals with is post-conviction issues on behalf of prisoners.
I think I worded that wrong. I think I was asking what options do we have that the appellate court, what remedies can the appellate court implement?
Okay, I misunderstood then. So the appellate court can't have another evidentiary hearing. Appellate courts aren't courts of record. They don't do any fact finding.
Okay.
If they think that there's something that needs to be pursued, they would send it back to what's called on remand for the trial court to pursue. So it can go up on appeal where it's at, and what the appellate court can do is say, we don't have a complete record. We're sending it back for the trial court to do more fact finding and to have a hearing on this issue. That's super rare. And then the other remedy they can come up with is that procedural errors in the trial that were pointed out in the post-conviction that entitle Ashley to a new trial, and they can order a new trial, or that the errors at trial were of such a nature and so egregious that they're going to reverse the case with no opportunity for a new trial. That's super rare, and John hasn't even asked for that. And then the other is, after reviewing everything, they say we don't find that Ashley's made a showing that she's entitled to a new trial. So those are kind of what the options are. Did I miss anything, Charee?
No, I don't know more about it than you do. But that sounds like you covered what I was thinking. Didn't it go back down in Stephen Avery's case once? Like, was it on the bones or something? But then the trial court judge just denied it.
Zellner had asked for about 4 remands, saying that this needs to go back so that in order to have an updated record, that stuff had come in, and we need to do this, updated record. And she did one on the new DNA tested, rapid DNA testing, which had resulted in a number of identifications of people who perished in a wildfire in California. And so she filed a motion to remand based on that, and denied. And then when it was discovered that a number of bones in the quarry were returned to the family, she filed a motion to remand on that, and the Wisconsin appellate court granted that one, and required then the the trial court said, okay, brief me on it, and then denied an evidentiary hearing anyway. And then it went back up on appeal. And then one of the issues on appeal was that they should have been granted evidentiary hearing on the bones, which I thought was a super strong argument. But yeah, there was some remands. Yeah, if something comes up before the appellate court decides and it fully gets briefed, you need to tell the court, look, we need you to send this back to the trial court for another evidentiary hearing before you decide the appeal. And I doubt seriously that that's going to happen. There's nothing new that has come up since the hearing in November.
Well, the good news is that Judge Moulter has now retired. So the original trial attorney who sat on the case, there'll be a new trial attorney now, if it is remanded back.
Judge.
Yes, I meant judge. Yeah, not trial attorney. Trial judge. Sorry.
Yeah, you just don't know.
Yeah, I don't even know. I haven't even looked into who.
The person who replaces Moulter could be 100 times worse. You just don't know.
That's true. So, well, we've been on here for 2 hours and we got through it. So I think, Travis, if you want to join us again next week, we usually work on Ashley's case every Sunday. Next week we'll be getting into Jasmine Parker's interrogation video, and
because the notes I have about the statement of facts, all of those can be incorporated in as we go through these things, like Jasmine, and because there's something in the statement of facts, we'll go over it next Sunday, that he mentions in the brief that Jasmine said she saw Nicole hogtied, and that Garrett asked for tape to tape her mouth so she would shut up.
It was actually, I think in there it said, Talitha said that Jasmine gave Garrett the tape because Jasmine wanted Nicole to shut up.
Gotcha. Yeah. So
you know what? I think another good idea I'll do is tomorrow I'll contact Shelley, the clerk, and see if we can get, I'm sure that we can get the transcripts from the evidentiary hearing, all of them. Because I think it would be a good idea to review everything. We tried to cover it ourselves just based on our notes on here. And we didn't get to go through the prosecutor's side. So I'll see if what those will cost and send her out a money order, and we'll get those.
Yeah, and you'll want to see what the, at least getting the indexes on those appellate volumes.
Okay.
Which is, that was referenced last week, that in this brief, he references a volume of exhibits. And
I think we have those. I think we have those exhibits that he submitted when he first filed for his the post-conviction relief motion.
It doesn't do you any good if you don't know what pages he's referring to. you can have them all. We went through that last week. I was trying to explain to you, unless on the clear plastic bag on her head, for example, I have no doubt, like Michael has no doubt, whatever document he's referencing says clear plastic bag. And
That would be,
unless you know what that page is by an index, and if there's not that many pages in that volume, just get the whole volume, get the index plus everything that's in that volume. But yeah, you very may well have what they're referring to, but unless you know what it is with certainty,
Do you mean that
it's not going to do you any good.
When you put together a record for an appeal, like then you'll be, when you write the brief, you'll be referring to page numbers in the record, which might not be the same as what you had in the page numbers that you referred to when you were in trial. Do you know what I mean? Is that what you mean? Because they're put together into one?
Let's see. I don't have the. Can you pull up the brief and?
let me see here. It's going to be at the very beginning, or?
It's you'll see references. Let me see if I can find it, and I can do it quicker here.
He's got all the cases listed. Let me see.
So you're looking how they reference things, and here we are, Garth brief appellant. So, for example, okay, so
right now, so what is because I have it right here. Right here is the exhibit index.
let me go back and see what you're looking at here. I don't see anything on screen. What?
Oh, hold on.
Now I got it. Okay, so and then what exhibit index is that from?
This is from the trial exhibits.
Yeah, again, that gotta have what he's referring to in the brief, which ain't that. He didn't refer to exhibits except one time. So let me pull up the appellate brief, and I'll show you exactly what you're looking at.
Okay.
So look at 7 of 43.
Okay. Where's that at on the page?
The last thing on the page.
Okay. PCR. Okay.
That's the PCR appendix, pages 200 and pages 208.
Okay.
You're gonna want the index from the PCR appendix.
Okay.
Go to the next page, and about halfway down it says in brackets TR Volume 2 161. So that's a transcript with testimony. I think that's trial transcripts. And then exhibit volume, pages 23, 28, and 48. You need the index to that exhibit volume.
20, what was it again? 23. I'm trying to follow you. 23 and what?
Yeah, forget what pages it is.
Okay.
It's the exhibit volume. That's what you want the index to.
Okay. Okay.
And without that, and then the next deal, exhibit volume, pages 30, 32, 48, 49, exhibit volume, page 40. It's all throughout the entire section. Unless you've got at least the index, I mean, if it's only 75 pages, you may want to just get the index and the whole volume. But unless you know what it is they're referring to, it's just a total guess. Now, some things it's going to be clear to you, oh, that's obviously this photograph. And in here, one time he does mention an exhibit number, and then it's going to be clear because you have the exhibit list. But these other, so on page 11, he mentions exhibit 50 showed Bowen wearing a white hat. So that one's clear, but these other ones where they mention an exhibit volume, you're just guessing. And it appeared clear to me that he got some stuff maybe that you're not aware of, don't have yet.
Okay. I'll check with her, and I will also check with him. I know that I'll have to go back through everything I have. I know I have everything, the trial transcripts and all of that. I've got 130 some pages of exhibits, the index for that. I've got the PCR, and I have the exhibits that were attached for that when it was submitted. So I don't know what I would be missing, but I'll find out, and then I'll try to have it all pulled in here together.
Yeah, you may not be missing anything. I don't know if the only thing you would be missing is if he offered something in the evidentiary hearing that he got from Lori James's file or from the DA. And then introduced it into evidence in the evidentiary hearing.
Okay. I don't think that he did. I think everything that he was introducing in the court, we already had a copy of, right down to Ray's autopsy. And I think that was the one thing that they didn't let come in.
Okay. He didn't even offer it in an offer of proof for record purposes.
Charee, do you remember what that was? Because I think the state argued that it was hearsay.
Yeah, I think they thought he should bring in whoever performed the autopsy, I guess.
Yeah.
Yeah.
Okay. Did he offer it as offer of proof for record purposes?
I think that he did, and it was still denied. That would be another good reason why we should get the transcripts. I'd have to go back and find. I know we recorded it a little bit. I can try to go back and listen and see what the argument actually was, but I don't. But that was the one. That was the one piece of evidence that the judge did not allow in.
Okay.
But they did allow. It was mainly about what he was trying to get in was the way the body was discovered, which was actually gotten in by Detective Smith that they put on the stand and through Detective Jenke's deposition that was admitted.
Okay.
So I will get all of that together and I'll have it ready next week, and we'll go through. If you want to make some notations, Travis, and let me know this week what I need to have in the forefront ready to go that you want to discuss. And then once we go through what items we want to pull out of the brief that we want to look at, he's referencing, then we'll get into Jasmine Parker's interrogation.
Great. I will do that.
Okay. All right, everybody. Well, thanks for being here. Hi, Kevin. I see you in the chat. Hi, Toby. I see you. Thank you, mods. Thank you, Travis. Thank you, Charee, for being here. I will get with both of you guys this week, but until then, good night, everybody.